Welcome to Pyramid Parent Talk. I'm Lynn Farlow.
And I'm Karen Harper Royal.
We're parents with Pyramid Community Parent Resource Center, providing information and support to parents of children with special needs in New Orleans. Pyramid Community Parent Resource Center, we will provide one-to-one assistance, workshops, and on special education law, positive behavior support, and advocacy skills. You can reach us on the web at www.pyramidparentcenter.org or follow us on Facebook at Pyramid Parent Center and Twitter, and follow us on Twitter at PyramidCPRC, or call our helpline at
let's see, our new helpline number is 504-218-8922.
Today we'll be talking to Eden Heilman with the Southern Poverty Law Center, and today she's going to give us an update of the Southern Poverty Law Center lawsuit against the state's Department of Education. Hi, Eden.
How are you guys doing today?
If you want to join the discussion, call us at 504-260-9265. And for Sprint callers, please call us at 504-943-8853.
Wait, that's 504-942-8853.
That's
if
correct.
You're a Sprint caller.
That's correct.
So, welcome, Eden.
Thank you, Karen.
So, what's going on with the Southern Poverty Law Center's lawsuit? It's been a while now, right?
It has been a while, and some people actually think that we have filed a new one because sometimes when there are new updates and there is some news coverage of it, people are confused and they're like, is this a new lawsuit? But no, it is the original lawsuit. It was actually filed back in 2010, and it's still going on right now. Sometimes, obviously, court proceedings move very slowly. And so, obviously, parents continue to struggle through these issues as the case proceeds. And we are trying our best to continue to represent individual parents who are facing some of the issues that are going on in New Orleans. But the case is still proceeding as right.
So can you give us a little background? What led to the filing of this lawsuit in the first place?
Absolutely. Southern Poverty opened, our headquarters are in Montgomery, Alabama, and we opened our office in New Orleans in 2007, obviously coming off of the back of Hurricane Katrina and Act 35 and the takeover of the state schools. The state's takeover of the school system in New Orleans. And right off the bat, as soon as we opened up our office here, and obviously my background and a couple of my other coworkers' background was in education law, we started getting calls from parents who were telling us that, there were parents of students with disabilities who were telling us that in this current system, they were basically, encountering multiple obstacles. The first big obstacle we heard was that parents were going door to door to try and find a school. As they were going to various schools were dissuading parents from attending. And that can take on numerous forms. So it may not be an outright, your child cannot go to school here because your child has a disability. It may be something more like, ooh, we don't have a teacher that specializes in autism. Oh, your child needs a paraprofessional. We don't have that at this school. You should look elsewhere. And so parents were facing these obstacles. And then we also received calls from parents whose kids were not being evaluated on the front end, who had been making multiple requests, but if they changed schools because of the kind of decentralized nature of the school system, those requests would just kind of fall by the wayside. And then we also encountered parents who, on the back end, were getting tons of disciplinary issues, kids who were being suspended well past the 10 days without having any of the procedural protections that the law requires. And so all of that kind of was what initially, piqued our interest in looking into this further and meeting with more parents. We started, obviously, meeting with groups like Families Helping Families, with Pyramid. Karen, this is when I think you and I first officially met back in the day, and really trying to get a sense of what the issues we were hearing from folks were. And we tried to do multiple strategies before going the litigation route. Our hope was that maybe some of this may have just been an oversight by the state system when the current system was set up. So we tried to engage in some initial discussions with the state about the issues we were hearing from parents, and we got met with, just kind of flat out denials that this wasn't actually happening, or that, we had a couple of parents who were making it up, or, it was just a few bad actors. And then we actually tried the legislative route, and we tried to get some legislation passed to try and address this issue of, the provision of special education in these new schools. And that didn't get a whole lot of ground. And then we actually filed a complaint, like an internal complaint with the State Department of Education, and we were not able to get any ground there. So basically, after kind of striking out in those three areas, our next process was to file the lawsuit.
Well, Eden, how can parents contact you at the Southern Poverty Law Center?
Absolutely. We would be more than welcome to hear from parents about what they're experiencing. And also the court, is constantly asking for stories from parents about what they're experiencing. So our number at our office is area code 504-486-8982. And parents are more than welcome to call at any point and share their stories with us.
So I would think that not every kind of problem a parent is having at a school is something that would make them possibly someone who should be a plaintiff in this case. What's the difference between just having a problem that needs to be solved and it really being something where you need to be a part of the lawsuit? How can a parent tell the difference?
Absolutely. Well, so the lawsuit itself actually, as I mentioned, it was filed against the State Department of Education. We did not name any particular school, charter school district. We did not name the RSD. We did not name OPSB. Basically, the underlying claims in the lawsuit are that the State Department of Education, set up this very unique structure in New Orleans where you have technically 60-plus different school districts operating in one geographic area, which doesn't really map out onto the current federal law in terms of educating kids with disabilities. And then after the state set up the system, they basically checked out. And so along those lines, we've identified very discrete areas where kids' rights are being violated by the current system. So, for example, one of the areas is child find. It's the failure of individual schools to actually conduct evaluations and make sure that kids are identified on the front end. One of the issues is very much the discrimination piece, which is that parents are being dissuaded and turned away from the door.
But let me just back you up for a minute and talk about the child find issue, just so that parents would understand exactly what that means. How would a parent know that they have a child find issue? Like they may be a part of the lawsuit under the child find. What would that look like to the parent?
It's a great question, and actually, frequently a lot of parents may not know that this is an issue. We've seen this play out a number of ways in New Orleans. The first way is a lot of parents are when they express concern to the school that their child may have a problem, the school will provide. First and foremost, they usually provide here a 504 plan. And it's very confusing, and I know typically what happens is some parents think that 504 is the same thing as being identified as a child under the Individuals with Disabilities Education Act, or IDEA, but they are radically different laws. Basically, having a child that has a 504 plan means that the child gets some minor accommodations for their disability. If a child's been identified as eligible under the IDEA, they get a substantive right to education, which comes along with a whole source of services and protections and whatnot. And so sometimes what happens is schools may recommend to parents that they get a 504 plan instead of being evaluated for the IDEA because it's cheaper. They don't have to pay for the evaluation. It's less burdensome for them, for the school district. And so parents may think that they're getting these protections by being just under 504 when, in fact, the kid may need more affirmative services and accommodations that they would be provided under the IDEA. So that's one thing we've seen happen. Another thing we've seen happen is that a parent will request an evaluation for special education, but then the parent will move schools for whatever reason. Either their current school closes down, or maybe they aren't satisfied with the way their current school is handling something, so they go to a new school. Well, because of the nature of the system in New Orleans, those requests for an evaluation doesn't necessarily transfer to the new school that they go to. So then they have to start the process all over again. And this can sometimes lead for kids being kind of stuck in the evaluation pipeline for years on end. And the third piece we've really seen on the child find thing is there's a program called Response to Intervention, and it's a good thing. Basically, the idea is that parents or students that need extra help, if they can get certain interventions, they may be able to not ever have to be evaluated for eligibility as a child with a disability, and that they may be able to get those interventions and just go from there. Unfortunately, what happens more frequently is that parents are told they'll request an evaluation, but they're told that their kid has to go through the RTI process before they get evaluated, and sometimes that process may take years, and parents are basically just trapped, or the kids are just trapped in the cycle of interventions that are failing. The child fails, but never actually goes on to get evaluated.
And speaking of response to intervention, for our next show, we're going to go deep into response to intervention.
And so if you are having some problems with special education in a give us a call here at WBOK. You can talk to Attorney Eden Heilman from the Southern Poverty Law Center. 504-260-9265. And if you're a Sprint caller, call us at 504-942-8853. So I believe the lawsuit, it's covering about 4 or 5 different areas. You talked a little bit about the child fine area. Is discipline one of those areas? Because that's the area we get the most calls about.
Yes, ma'am, it is absolutely covered, and it is a very serious issue, especially in this region. And one of the issues that kind of brought us to this was some of the outrageous suspension numbers that we were seeing. We had some clients, kids with disabilities who were being suspended 40, 50 school days a school year without any of the procedural protections that the law requires. And just to back up a little bit and explain, under federal law, if a child with a disability participates in some sort of behavior, that child can be suspended up to 10 days before certain procedural protections kick in. And once those procedural protections kick in, the school or school district has a responsibility to ensure that the child gets those protections so that they're no longer being disciplined for something that may be a manifestation of their disability. And so what we saw, what was happening, is that those procedural protections were never kicking in, and kids were being suspended just outrageous numbers of days without ever, getting any follow-up education or any educational services past that 10th day.
So I recently heard that there's a program at one of the schools where we have a lot of kids with disabilities, even some without, but maybe they should be identified as a kid with disability. So the school's not putting them out. They just have a special little programs on one of their campuses. Kids come in for a partial day. Is that illegal?
It's a very good question, and frankly, the law is a little bit all over the place on this. So the underlying foundation is that the kid is supposed to be in their IEP setting, so their individualized educational program setting, and that they should be receiving services that would give them a free, appropriate public education. So depending on what the circumstances are, if they are sitting in a room without education, without instruction, without receiving their IEP services, then the argument could be made that would be considered a suspension.
So is it okay for the school to just give my child fewer hours of education just because he's a special needs kid who happens to have a lot of discipline problems? Let's say instead of him going to school from 7 a.m. to 4 p.m. like everybody else, he comes in at 10 and goes home at 1.
Now, that's another great question, and we've seen this issue happen again and again. Basically, unless it's part of a child's individualized education program, the answer is no. So that we call these undocumented suspensions because the school district wouldn't record those as a suspension. They'll just basically call a parent and say, hey, we want you to come pick up your child at 1 p.m. today, and they won't give you any paperwork to reflect that. In that case, those are suspensions, and I think very clearly the law would consider those suspensions. If a child would need a shortened school day for whatever reason, because their disability, for example, causes them to not be able to stay in class for longer than a certain period of time, then the proper procedure would be for the IEP team to meet, consider that, and if it's agreed upon, it would be part of the IEP.
So if we have parents who are in that situation where the kid's going to school for just a partial day and the IEP doesn't reflect that, should they contact the Southern Poverty Law Center?
We would encourage them to contact, absolutely.
Well, Eden, we have a call. We're going to take caller on line 3, Walter. Walter, are you there?
Hello, I'm here.
What's your question?
Oh, first of all, wonderful show. I have so many questions, but, let me just start with this. if my child has an IEP, does he automatically have those rights that you just spoke of?
Yeah, so yes, and this is where it gets tricky. Sometimes a 504 plan is called an IAP. A is an apple. And then a plan under the IDEA is called an IEP. So sometimes there's some confusion between those two. But if your child has an IEP, which is an individualized education program under the IDEA, then yes, their rights would follow from that.
Okay. Next question. Have you considered in your lawsuit, when you filed it, how long ago did you file it, by the way?
It was filed in October 2010.
When you filed it, did you consider filing also a TRO, a temporary restraining order, with a preliminary injunction to assert that there's been irreparable harm and the fact that these kids are living in this environment and years are going by?
Walter, are you a lawyer?
No, I've just been around enough of it.
Yeah, I was going to say, you know your lingo. Actually, yes, we did file a preliminary injunction. What basically ended up happening was, and just to kind of save everybody the procedural back and forth, what basically happened was we consolidated it into a fast trial. The preliminary injunction raised a lot of the same issues that we raised on the merits, and so we consolidated them into an expedited trial schedule. Where we stand currently right now was that the court is currently considering whether or not to certify this as a class action. If it gets certified as a class action, then it would cover all interested parties of children with disabilities that would basically fall underneath it. Of course, folks can opt out. If that happens, if it gets certified as a class action, the next stage would be going to trial. So, yes, we did file a preliminary injunction, but unfortunately, like I said, it all has moved very slowly, considering kind of just the vast majority of motions that have had to be filed and responded to.
Okay. And then another point, I know you're dealing with specific issues with special needs children. However, have you considered amending the petition or having another intervention by someone else in your petition to suggest that it's taxation without representation? What I'm meaning is that the parents of these special needs children who are paying taxes to subsidize or to provide these services aren't being represented by any boards that oversees these 60-some-odd plus individual school boards, if you will.
Yeah, no, you raise an excellent point. Unfortunately, I think that would be a separate issue, so it would probably be hard to try and join anything like that in the current lawsuit. The current lawsuit is fit very squarely kind of underneath the federal laws that guide the education of children with disabilities. But I think you raise an excellent point, and one that we've frequently heard from parents about the fact that there is no outlet, there's no local school board, there's nobody for them to go to express their concerns.
And have you expressed it with some of your colleagues, and what would have been some of their thoughts about? I mean, obviously no one's brought a suit yet, but I was just asking what would have been some of your responses to that.
Yeah, I think most people are very concerned about this issue. I can't say what kind of, where various lawyers are in terms of what they're looking at in terms of future lawsuits. I know that all angles have been looked at and are being looked at currently. So. Okay.
Well, I appreciate it. I think this is one of the best shows, that we have on the air, and I just thank God for Ms. Royal and for the guest that she brings on the show. I think it's a great opportunity to be heard.
Thank you,
Thanks, Walter.
Thank you.
All right, we have another caller on line 1, Miss Carol. Miss Carol, are you there?
Hi.
How you doing?
I'm here.
Thanks for calling.
Hi. Thank you for having this show. I'm wondering if it's a rather unique situation. I have a son who has an IEP. He has been one of the rare black males that has been able to receive his gifted diagnosis. So I'm grateful for that. Yes. However, I'm experiencing some issues with his school. And he also actually has speech. He's enrolled in speech because of some articulation issues. Early on when he was a young child, I sort of noticed some issues with his hearing. And so after taking him to some specialists, I'm being told that he may have what's called CAPD, communication. I think it's central auditory processing disorder.
Yes.
And so, are you familiar with that?
I am familiar with central auditory processing disorder, yes.
Wonderful. So actually, last year he was, the principal allowed him to receive 504 accommodations because his grades were suffering. And so this year, his grades were suffering also at the end of the school year. And so they called me in for a meeting. But now during this meeting, they talked about removing the 504 accommodations for him. And so I was told that they were most likely temporary. I wasn't told that initially. My husband's concern is that if the 504 accommodations are removed, that if he happens to have an issue with the LEAP test, because it's in the 4th grade, that that will impact our recourse if he happens to have an issue with the LEAP test. Is that something that you guys could shed some light on?
Okay, so what it sounds like, I'm sorry, you wanted to add something else?
Oh, I'm sorry, I couldn't hear you.
Oh, I was going to tell you, when you say they want to take away his accommodations, was that so that they could perhaps implement a IEP for his for the central auditory processing disorder?
I'm actually not sure, because when they talked about removing the 504 accommodations, they talked about maybe moving some of the I guess what are called accommodations into maybe an IEP or an IAP, just moving them, so that he won't. I don't know how.
Well, let me just be clear. If he has speech, he already has an IEP. If he's gifted, he already has an IEP, and that speech and the gifted services are on the same IEP. And at the one of the last pages of the IEP is the accommodations page. And and so he wouldn't have a separate 504 plan. So he's getting he's entitled to those accommodations that are written on that IEP. And in order for that to be changed, you would have to sign a new IEP. So they can't take them away unless you agree to them being taken away. The IEP document also should specifically say what types of accommodations he's going to get on the LEAP test or whatever other tests they put in place as we move forward to the Common Core test. So I would encourage you to take a look at the IEP and see what the current accommodations are. If you think that there are some that should be checked off that are not checked off, definitely bring that up. Eden, is there anything else you wanted to add regarding that situation?
Yeah, I would just say, again, this goes back to the issue of what Karen just mentioned. I mean, I'm assuming if your son already has an IEP, just to kind of clarify the difference between having a 504 accommodations versus having an IEP. Being eligible under the IDEA and having an IEP, you are automatically eligible under 504. So, and this is a little bit confusing because some parents will be like, okay, well, we have an IEP, but we also want 504 accommodations. An IEP is actually greater and more expansive than getting 504 accommodations. So that would be kind of the place to start and go with that. If you are a parent that just has 504 accommodations and you're worried that your child may need additional services, you may want to consider requesting an IEP if you don't already have one.
And one other point I wanted to get clear, has the school evaluated the child regarding the central auditory processing disorder? Ms. Carroll? Hello? Oh, I think, okay, Ms. Carroll, it looks like you've hung up. But you might want to check with the school to see if they've done, if they will do an evaluation so that they could implement some of the recommendations out of that evaluation that are problems due to the central auditory processing disorder. And our time, I cannot believe our time is running out so quickly. But I want to give you some more time to talk about the lawsuit, Eden. So this lawsuit's been in place for a long time. How much longer are we looking at, and what does a win look like? What will we see happen for children if you are successful in this lawsuit?
That's a great question. And yes, you are correct. It has been in place for a very long time. We actually just celebrated its 3rd birthday.
Oh, God.
Just a couple of weeks ago. Like I said, I think, and this is actually, I didn't really fully answer your question earlier about, obviously about parents being participants in a lawsuit versus getting their individual problems resolved. But the individual problems, honestly, if you can get them resolved at the front end, it obviously is much shorter and takes a lot less time than waiting out throughout the course of time for a lawsuit. I can't tell you how long it will go. Like I said, we are kind of in the last stages of probably what will happen leading up to trial. So theoretically, if a class gets certified, we will go from there toward trial. My guess is that would happen probably early to mid 2014. But there are appeal processes even in place with the class certification piece, so that may change the timelines. In the interim, like I said, we are continuing to work with parents individually on resolving their issues. A win in terms of how we can address this issue. The lawsuit is not for money. We are not seeking any damages or any compensatory education. What we are seeking is what we call injunctive relief, which basically means that it would force the state to take certain measures to fix the issues that are happening with these schools. And so that may be increased monitoring, supervision, training, accountability, all of these things to make sure that schools actually are, knowing what they're doing and able to serve students the way the law requires.
And if someone thinks that their child's issue would be good for the lawsuit, how should they get in touch with you?
I would encourage folks to contact our office at 504-486-8982. We have an intake process, and we can't represent every single case that comes through our door for a variety of reasons. But what we can do is get folks a story. We can share them with the court periodically when needed, and we can really help try and refer people to the right sources. So, yes, we encourage people to contact us if they're having issues.
Well, Eden, we want to thank you for joining us and updating us about the lawsuit. And please definitely come back when we have some more information, hopefully some really good news about the outcome of the lawsuit.
Great. Thanks for having me.
We want to remind people that we have another very important event going on in New Orleans regarding education this week. That's the Zoom In, Zoom Out conference, November 15th through the 17th. On Friday the 15th, it's at the Community Book Center at 6 to 9 p.m. And then Saturday and Sunday, starting at 10 a.m. at the Sojourner Truth Community Center at 2200 Lafayette Street. That's the Zoom In, Zoom Out conference that brings together culture and power in our city schools.
Also, remember to tune in to our next show on Tuesday, November 26th. Our topic will be response to intervention. Also, if you have any concerns regarding your child with a disability, please contact us on our helpline at 504-218-8922. And please like us on Facebook, Pyramid Community Parent Resource Center, and follow us on Twitter at Pyramid CPRC. And please remember, you are never alone.